p.m. This is the plaintiff's motion regarding parenting time. Plaintiff is present, represented by Attorney Dawn Young. Mr. Jenoff appears in pro se, represents himself in this matter. Both parties, please raise your right hand.
This is our motion for suspension of parenting time. Sierra Sprague is the plaintiff in the above caption matter. She's a biological mother of the children, has divorce judgment dated June 9th, 2021 as a parenting time is set forth. With respect to Harlan Janoff, the parenting time, the parents during the school year shall be every Thursday after school or Friday, Thursday or 4 p.m. if there's no school until Saturday until 1 p.m. Until Linden is 1, and the defendant should have the same parenting time within it as he has with Harlan. It's further orders that the adjudged parenting time is given on the holiday schedule according to the front of the court and policy time. Our motion is here in the court because Mr. Janoff, while having parents, is currently having parenting time with the children. It's only 4 overnights a week and 4 overnights a month, and he is not properly supervising the children. His current wife is going through a divorce with him and has his location on. When he's has the children, he's either not supervising them or he's driving them around barracks without a license or with other people who are under the influence who do not have a license. He currently has no license and was charged with the second operating while under the influence in Huron County District Court.
Okay, let me stop you right there. That second part. The court takes judicial notice of its records, and the court reviewed the register of actions relative to any recent charges involving the defendant in operating while intoxicated. There's nothing.
Okay.
Nothing as of 24, 23. There's nothing open. There's nothing pending.
Okay. Okay, and while he's having his children, he's driving around with a license that is suspended, or is having children with other people who are under the influence. Is posting this on Snapchat. Other people, Your Honor, have contacted my client in regards to Mr. Janoff's reckless behavior while having the children. They have been under the influence with them and seen his behavior with the children. At this point, we believe that it is dangerous for the children to stay having parenting time with Mr. Janoff, and we'd ask that ask that this court order parenting time to be suspended with the said minors children until parenting time is reinstated. At that time, we would ask for counseling, addiction counseling, rehabilitation program, or recovery meetings 90 days within 90 meetings within 90 days, or whatever this court sees fit.
Ms. Young, I'll treat that as an ultimate. Do you have any witnesses you intend to call in this matter?
No, Your Honor.
Mr. Janoff, your response.
I don't have any substance abuse issues, Your Honor. I'll submit for a drug test right now. I worked for Gold Rose Construction. I do concrete. I like to come home after work and have a couple of beers. That seems reasonable. The boys are always properly supervised. I live with my grandmother, which is their great grandmother, and the one night she's talking about, I went with a friend to gather a place after the boys had went to bed to get pizza and a couple of treats for a friend's birthday. And the boys are never in a vehicle with anybody else that is ever under the influence. Anybody, it's always my mother, great grandmother, or my grandmother, their great grandmother. I took them to the movies one time with my friend, which is their godfather. and nobody had, because he had his boy too, and they're best friends. Nobody was drinking, nobody was under the influence of anything. I don't drive the boys around. If I ever have to get anywhere with them, my grandmother drives, or my mom drives.
So fair to say you don't have a license then?
Right,
Okay, fair enough.
but there's never an instance where they're put in a position where there's somebody without a license that can get them to the hospital for medical care or anything like that. There's always somebody in place to be able to do that.
Do you have any witnesses you intend to call?
I don't. I just found out about this last week, so I got paper served to me. If anything, I would like request adjournment to seek counsel, but I don't think I need that. I don't think there's any reason for that. Like I said, I can go submit for a drug test right now for any substance abuse problems. There is none. I barely even use marijuana, so I don't. And the letter from this Hannah Marie, I have talked to her like twice in my life, and that's after she was just in her recent thing with Cody Miller, and she wanted comfort from my friend who drove me to Bad X, Kenzie Lasowski. She was just seeking comfort from her and wanted us to go over there and talk. Nobody was partying, drinking, nothing like that. I don't really have the means to subpoena her in here, but
What can be done if need be?
right, I don't think there's any reason for this, Your Honor.
Okay. Ms. Young, anything else?
Yes, also, while the children are, being at the home, they're not being cared for properly. The Harlan comes home and reports to his mother that.
Well, we can't get into hearsay.
Okay.
Can't get into hearsay, but you're alleging that there are problems.
Yes.
Well, there must be proper cause for change in circumstance at this point to review the parenting time in this matter. And at this point, the court's going to take the matter under advisement because the court's going to do a couple of things. Number one, the court is going to order, if it's not already in the original judgment of divorce, that the defendant is not to consume alcohol or controlled substances unless duly prescribed 8 hours prior to or during the parenting time, number one. So if it's Thursday through Sunday, there is to be no alcohol consumption, no marijuana, prescription drugs only as prescribed if you are prescribed those medications. And the court will order, based upon your own statement that you would be willing to do this, that you are to submit to testing a chance for change or chance to change here in Bad X. And we'll order that. When's the next parenting time scheduled?
Today.
We can do a test today. Test today. And Ms. Schultz, what else would you recommend during that time? A testing procedure, a testing protocol here so that we can address it.
Is the court looking for testing for a 30-day period or?
Because it sounds like he only has the children 4 days a month.
So would you like? We could look at a 30-day period where we do testing prior to each period of visitation. So we can certainly set it up so that the test would be on Thursday or Friday of that week. My concern would be what the work schedule is like, if he's working out of the area, how that may impact.
And Your Honor, I could go today and do one, but like my financials aren't the greatest. If she wants to go ahead and pay for each test, I don't see why I should have to take one every time before I get the boys unless she's gonna do the same. But,
Well, it's not being alleged that she has the issue, it's alleged that you do.
right, alleged, which is all hearsay because there's no.
That's why I said alleged. I don't know. I don't know.
Right.
I've not made a determination. But we'll test today.
And I do work,
What is your schedule?
pigeon, sometimes I work on bottoms, so I'm all over the place. 8 to 5 every day, except for Saturday and Sunday.
You're not working on Saturdays?
No, but I have the boys on, when I do get my boys every other weekend, it's Saturday and Sunday, and we usually wake up and try to go to my mom's and do something with the boys, so they're with family. And I never take them really anywhere because I don't have a license, so it's usually cook out to mom and dad is where we go.
We'll test today. We'll test Saturday. And it's every other weekend then. That's what you just said. I thought it was 4 times.
Is
Right.
this Mr. General's regular weekend or only his holiday?
This one would be a holiday weekend.
So you'll have the children again next weekend?
Yeah.
Well, that's 2 weekends. I'll also order home inspection.
They just came and did that. I was gonna find out about subpoena and the CPS, the caseworker that came.
I'll ask Mr. Bolton to do that. Yeah, in front of the court.
Okay.
I will also order that while this matter, well, I'm just gonna order it in general, you are not to have the children in any motor vehicle that you are operating the vehicle. You don't have a valid license.
Right, I don't do that anyways, but yes.
And as to the payment for the testing at this point, the first, depending on how the test results are, at this point, I will order 50-50 here. If there are 4 tests, you pay for 2, mom pays for 2. Now, on the flip side, if those tests show positive, whether it be for alcohol or illegal controlled substances, I may change that decision and put that expense exclusively on you.
Okay, so I'm not allowed to use marijuana or alcohol at all, or?
Not when you have the children.
Right.
When you have the children, you are not to be ingesting any marijuana. You don't have I'm assuming you don't have a medical marijuana card, correct?
I used to, but no, I don't anymore. But are these tests gonna be like a breathalyzer right when I get there, or?
Chance to change knows what they're doing there regarding the testing. I'm not sure how they test, but they're going to test for alcohol and for illegal controlled substances.
I had experience with the testing for chance to change, and the alcohol shows up for 72 hours. I know the levels fluctuate on whether how much, because I always would get a breathalyzer when I went, and then the ETG scan, which scanned for up to 72 hours. So I have a beer the night before after work that I get the boys.
It's gonna be up to you. That's gonna be up to you at this point. I mean, I don't believe they have a preliminary breath test over there, do they? They do? Okay. I'm going to give it to them regarding the testing in this matter. You are not to consume alcohol or any illegal controlled substances 8 hours prior or during the time of the parenting time.
Okay.
And the court will hold this matter under advisement and we'll reconvene. I'd like, did you suggest 30 days to Schultz?
Yes, Your Honor. And I just want to clarify, for each period of visitation, the court is ordering a test twice during that weekend?
Yes, at the beginning and on Saturday.
Prior to the start and again on Saturday?
Yes. No, matter will be taken under advisement. We'll reconvene in 30 days and we'll have that next date.
July 12th.
Be July 12th.
So what is this test today and tomorrow?
Today and Saturday, yes. We'll see you in 30 days. Thank you. Prior orders do remain in effect. Is in pro se. He represents himself. Any update regarding this file?
I would just note, as the court is aware, we did enter an ex parte order. Based on its first round of testing, that parenting time was subsequently reinstated at June 21st as the testing showed negative for all substances. And our office received a parenting time on July 10th, alleging that he was denied the weekend following the 4th of July, but he did include that he did not test for that weekend.
Ms. Young, did you hear all that?
It was a little reverby, Your Honor.
As I understand it, parenting time was suspended on June 14, 2024, based upon a 3. It was reinstated on June 21st, 2024, because of a negative. And then for the, I believe it would have been the July 4th time frame, the next parenting time for father, his parenting time was allegedly denied by mother, and as a result, he never tested. Is that?
Yes.
That's what was stated.
She never denied any parenting time except for when he was negative and when he was positive.
Okay, let's place both parties. Ms. Young, do you wish to question your client about this before we go any further?
Yes, Your Honor. At any point, did you deny parenting time to your client? I mean, to Mr. Janoff?
No, I did not deny parenting time with him. We went off of our front of the court schedule that we were asked to go off with by front of the court, which stated that 4th of July was my weekend. So I kept the children for that holiday.
Thank you, Your Honor.
Sure.
The 4th of July holiday under the parenting time guidelines is July 3rd, 4th, and 5th. The way that the holiday fell this year, they would have a weekend after the holiday, starting at 6 p.m. And that is the period of question, July 5th through 7th.
I see. July 5th and 7th.
Yes.
Ms. Young, do you wish to question your client regarding that as well?
No, Your Honor.
I will. Did the children go to father on July 5th through the 7th?
No, they didn't. I had them for that holiday weekend. So
according to the front of the court guidelines, your holiday would have been through July the 4th, but 5th through the 7th would have been father's time.
okay, I was under the impression that that holiday weekend from the 4th to the Sunday would have been mine. So that was my mistake. I didn't realize with how the holiday fell that I would give him his time on the 5th through the 7th. So I apologize for that.
No need to apologize. We have clarity.
Yeah, nope, I apologize. Nope, I didn't realize that.
All right, Ms. Young, do you wish to provide any further proofs?
I'd just like to say, Your Honor, that Mr. Janoff was very adamant with this court that he did not use any substances and that he would test negative with all drug tests, and that when he wasn't prepared, that he did test positive. When he knew ahead of time of the court proceedings or the testing, he was prepared, then he tested negative. But when he wasn't prepared, he tested positive, and that we were just asking that parenting time be suspended.
Jenna, response to all this.
I would agree with that because went back the next day to test and I didn't get back negative. I went that Friday at court and then Saturday, and I've done testing before. I had 2 false positives. It's not bad, but I didn't have the money to do that. So
You don't deny testing positive, though, right? Or you say that
the test came back positive, but I came back the next day and everything was negative. So
what could have been through your system too.
But I also wasn't taking care of children at that time, but I understand.
We're talking alleged illegal substance. You understand?
Right, I didn't see how it was something to get to my system.
You did test negative for the second test. That's why your parenting time was reinstated. You ran a test today, what would it show? Did you have any questions?
No, Your Honor.
When's father's next scheduled parenting?
Next weekend.
Next weekend?
Yes, Your Honor.
You thought it was this weekend?
Yeah.
I can't hear you with that dehumidifier, a little bit, and you're speaking quiet, so. But you believe it's this weekend?
That's what I thought all week, I guess.
Well, let's, I'm
Of the board provides that for summer break parenting time. Parenting time is as agreed to by the parties. If they cannot agree, Mr. Dunlop has at least 2 overnights every week. That's the order, but I don't believe that's what part of that.
Well, that throws a bunch of us.
When we were last year, my understanding is that we were doing
That was my understanding. Is that your understanding as well, sir?
That's what they've been doing, and I knew that I was supposed to get them 2 overnights every week. I've just been trying to do this.
Your Honor. So for the 2 nights every week, I think it's like Wednesdays or Thursdays in our schedule that those days he can have the children. And he's never once tried to meet up to do that. He doesn't have a license. So we've just been following that every other weekend. And it's never been questioned by the other party. So that's what we've done. For the July weekend, would have fell technically on his weekend, but with it being my holiday, I kept them. So then this next weekend would be scheduled to be mine. Again, I know I made a mistake on that weekend with how the week fell, so I apologize for that, but, that's where my, understanding of the weekend is, just so you could have some clarification.
Thank you, Your Honor. We've been following different guidelines this whole time. She just decided to switch guidelines because that's what kind of words that they're going by now. But we were going by with something during COVID guidelines. So she had them for Memorial Day, which would have made 4th of July mine. But then she decided to switch things up. So she wanted Memorial Day and then she decided to switch. Somehow 4th of July was on hers.
My understanding from prior communication with Lita, with the friend of the court office, is that they were using the state court administrator office model parenting guideline, which is not what the judge guidelines, and those are not the same set.
Sounds court parties have their own, which they're entitled to deal according to the judge. So I guess the question is, you have not made a decision regarding reinstating time yet. You have plans with the children this weekend?
I do, Your Honor. And we were following that schedule because that's what we were given after our divorce was finalized. I was given that by the Salem's office that I was working with at the time. So we didn't, yeah. And then we were just told once this motion was opened up by friend of the court, we weren't using the correct one that they go off of. So we started using that after we were given that. I was not aware of that until just recently, just so you know. Sorry, I just wanted to give you an explanation on why the switch, yeah.
Ms. Young, did you have anything further to add to any of this?
Just that the client is correct. She was following a different schedule given to her by Mrs. Salins. And then when I got involved, we decided to follow the friend of the court order, and then she's been going forward with that.
Jenna, so it's not your motion. Do you have any final comment?
Just that She was supposed to take half this testing, I haven't been reimbursed for it at all yet. That's all.
All right, this is what the court is going to do. This is a motion regarding parenting time suspended after the father was suspended for a period of time based on a positive screen. That screen was subsequently negative at a second testing. The July holiday, mom celebrated with children, and July 5th and the 7th, the children were not returned pursuant to the court order. Parties have been engaging in this parenting time on their own, which they're entitled to do it, so long as the parties mutually agree, then certainly they can have parenting time any way they want. However, the court order is the court order in this case, and first, the court finds that father's entitled to make up time for the July 5th or 7th time frame. That has to be scheduled, put together, and utilized within the next 6 months. So you can come up with a time frame for those days that father is, that would be appreciated by the court. Relative to suspension of parenting time in this case, there was a positive test result, there was a negative test result. The third test was not administered because mom did not provide the children. The court addressed that already. The court will resume the original order in this case only when father submits to a final test, and that test will be before his next parenting time, which I believe will be this coming Friday. Not today, but next Friday. What time is the parenting time you get? I usually, before the children are picked up, I want a final test. I want to, at least, you work, correct, sir? No later than Thursday evening or Friday morning. Of your scheduled time. I want to test. Test is negative, parenting time resumes. If the test is positive, parenting time is suspended. So father files a motion. Any questions regarding that? Certainly. Regarding payment of testing, the first test is the responsibility of the father as he tests positive. Second test, the court is going to order as it was negative. That is the payment of Ms. Jenoff. Third test, we'll see how it goes. Third test is positive. It's going to be father's responsibility.
Your Honor, and I think this is what Mr. Yamamoto said. You did order that it would split, but you did have another weekend that experienced possible Friday and Saturday.
Oh, okay.
It was the third round of for holiday at July 5th. That was not, but there were 4 testing.
So that's splitting. Splitting. Let's see what the last test is prior to. Anything else? Thank you.
Thank you.
Ms. Young, also too, can you give the court a call this afternoon to show cause Ms. Marshall for alleged denial of parenting time on May 20th? Ms. Marshall is present, represented by Attorney Dennis W. Reed, Mr. Yonitz, and Pro Se. Can you both please raise your right hand? So you're for the front of the court.
On March 14th of this year, a stipulated order was entered regarding parenting time. After alternative dispute resolution, that order provided that Mr. Yan has supervised parenting time with the minor child as the third evening. In the event it's not agreed, parenting time is to be exercised on Mondays and Fridays from 4 or 4:30 p.m. and 7 or 7:30 p.m. The friend of the court office had received a complaint from Mr. Yan alleging that he was denied his parenting time on May 20th of 2024. The information submitted did indicate that he had not arrived for the visitation by 4:30 p.m., but he did take appropriate steps to notify Ms. Marshall that he was en route from work. And so I would just ask this court to address whether the summer parenting time schedule should be modified to coordinate with his work schedule. My understanding is that during the summer months, they do work a little bit modified work schedule, or perhaps a 5 o'clock visitation better. But otherwise, it's just
Thank you. Mr. Young, you contacted the front of the court regarding alleged denial of parenting time, right, sir?
Correct.
And was that on for May 20th? And what is your understanding of the current order regarding when that parenting time is supposed to be?
What can you explain more about that?
Sure. When are you supposed to begin your parenting time? What time is it supposed to begin according to the order?
So according to the order, by between 4 and 4:30.
Okay. And were you able to show up at between 4 and 4:30 to begin that time?
No.
Why not?
I was still at work. We were working late because of the holiday.
Okay. And you work here locally?
Around, sometimes, other times it's down for Huron or Contempt.
Okay. So did you notify Mom that you were going to be running late? And I did read the text message. And did you get a response?
Not as quickly as I thought I was going to, but she did respond eventually, yes.
Okay. And what was her response?
Said if you're not here by 4:30, you can't come.
Okay. And so did you still make an attempt to see the child?
Still made an attempt. I also called up here to make sure, ask questions to make sure. They, from my understanding, they said as long as they're there before 5, they won't count it as a forfeiture. So then I got there by 4 or before 5, and then doors were locked. Nobody answered as I was there.
Okay. I did read something about you contacted the front of the court and they told you something about a half hour.
Yeah, they said like a half-hour grace period past 4:30. Talked it here.
Mr. Reed.
Your Honor, there's a bit of a history to the case, so bear with me while I run through it. Back in the fall, both parties signed a stipulated agreement regarding custody and parenting time. And that was their first agreement. And within a month, Mr. Young was unhappy with that, and he filed a motion to modify custody. Your Honor denied that motion, but did refer to the issue of visitation to the friend of the court mediation. We all appeared at mediation. All of us entered into I think, a good faith negotiated agreement. And Schultz was there. There was a younger lady, I think an intern or training or something, and she participated in it as well. During the course of that meeting, I kept notes about what we were agreeing to. And what we agreed to was that we would have a 6-month review of expansion of his visitation rights on September 2nd at 3:30. In addition to that, we agreed specifically Monday and Fridays, 4 p.m. to 7 p.m. And we all agreed on that. Later in the conversation, Ms. Yan announced that, well, I might not be able to be there at 4 o'clock on occasions. We accommodated him, and we put right in the order the 30-minute leeway. That's why the order is drafted the way it is, because in 40 years of practice, that's the first time I've ever drafted an order, or seen an order drafted, or approved an order drafted like that one. And what we did was, instead of ending his 3-hour visitation at 7 p.m., so if he showed up at 4:30, for example, normally visitation would end at 7 p.m. But we built right into this order that 30-minute leeway. So that if he shows up at 4:15, he stays till 7:15. If he shows up at 4:30, he stays until 7:30. That's why that language is the way that it is. So whoever told him he has until 5 p.m. did not participate in the mediation and is misinterpreting the language of that order and why it's drafted the way that it is. Because we didn't discuss, nor did we agree upon 5 p.m. We just didn't do that. We discussed that he would be there within that 30-minute window, and then he'd get 30 more minutes at the end of the 7 p.m. cutoff if he were late on occasions. Now, this business about summertime, I've indicated to the court in my response paragraph 2, immediately following the March 14th order, on March 18th, 4 days later, he shows up late. My client was able that day and allowed him to stay until 8 p.m. Canceled May 31st, because he couldn't be there. And he was getting late on June 3rd. So what's happening here is that it isn't just on occasions or seasonal or during the summertime. It appears that it's just starting to happen almost all the time. And my client has a schedule as well. If the court modifies this court order, it'll be the third modification since October to accommodate this gentleman's schedules. Now, we went into mediation because Your Honor ordered us to in good faith, and we made a deal. These things were discussed. We made a deal. And now we're here because someone at the front of the court's interpreting the order, the mediated order, differently than what we agreed to. This is scheduled for review in September. I don't think it should be changed in June. I don't even think we should be here today. Because using a show cause on something of this nature, if Mr. Yan is having problems and he can't follow the March order, then he should file a motion. And we should come in here and he can present his reasons as to why he needs to modify the order for a third time. But doing a show cause hearing on someone who is following the court order, to me, is excessive and just shouldn't be done. If there's some issue, how about a conversation with both sides? I'm still her lawyer. Nobody's bothered to call me about this. Haven't heard a word about it. Until, in fact, I wasn't even served with the motion. They sent it directly to my client. I'm still her lawyer until September. Nobody bothered to call me about it being a problem. I think this thing should be dismissed. The order should remain as it is, and he needs to follow it. That's what we agreed to.
I'd like to add, Your Honor, is that the order language does include that parenting time is as the parties can agree. So generally speaking, when we include language of that effect, we want the parties to have a little bit of negotiation room, such as the instance where it's 15 minutes that was adjusted to the visitation on March 18th. Or I apologize. I was not under the impression that Mr. Reed was representing through September, so the front of the court office did not serve him with all these proceedings. I will make sure that that is updated in our records. But our general parenting time policies do allow 1/2 hour for emergency purposes and require that the other parent provide notice of that. So any staff that would have provided that information provided Mr. Yan with notice of what the front of the court policy is. So the order does not include that 1/2 hour grace period is already built into the time frames, and perhaps we need to clarify that so that if other individuals are working on this file, that is done.
Coach, can I add one thing?
Go ahead.
Briefly, just briefly. My client reminded me this morning that when we made this deal at the front of the court's office at mediation, she specifically asked Ms. Schultz and the young lady who was really the one kind of conducting the mediation that day, if he doesn't show up by 4:30, what do I do? And do I have to let him see the child after that? And the response from at least the young lady that was there helping was, no, you don't have to, it's up to you. She reminded me of that conversation this morning. That's our memories of what happened that day. And that's why the order is drafted in the way that it is. If we were not agreeing already to build in the 30-minute leeway, why would we agree to 7:30? There's no reason for that. We agreed 3 hours of visitation. And that enabled him that leeway time that the front of the court, and I think most front of the courts allow that. But in this case, we did it so that he'd get a full 3 hours and not be deprived of 3 hours if he shows up late. That's why we did it that way.
Yeah. What's the matter with 4 or 4:30?
There's times where I don't get out of work till 5, if not later than 4:30.
Was that the case when you originally reached this agreement?
Yeah. So getting up late.
Well, no, wait a second though. Why would you agree to something that?
At the time when we did the motion, it was my winter hours.
Okay,
So I
that's
was
what I'm
getting up
asking.
early.
So what are your winter hours?
They vary, but most of the time I'm usually out before 4. So then I would always have time, but now that we're getting back into our summer hours, it's pushing 5, 6, 7 o'clock now.
If I may, the ADR report that was filed before under paragraph 6, it was filed on March 8th, 2024, prior to entry of the stipulated order, does include that concern was addressed. That the parties do not agree on summer parenting time if it conflicts with the defendant's work schedule. So that was,
So
it was part of our discussions during ADR.
okay. All right. What's mom's schedule during the summer?
It varies as well, Judge.
Okay. Well, the whole idea here is for father to have parenting time. And I'm not going to get into the mix of what was said by one party or by the friend of the court or anything like that. I think we have one hell of a good friend of the court. That's just my opinion. I can say that, and that's just my opinion for what it's worth. And the whole idea, as I said, is to allow bonding and time with the father and the child. And it appears that mom has been accommodating by the fact that, you know, you have this half hour here and there to try and make this thing work. Ms. Schultz made a good point where it's clearly, it was a bone of contention for summer because it was already discussed during the ADR process, and we're in summer. And I'm not going to state what this gentleman does for work, but there are summer holidays, a lot of Mondays, and the hours are, I would assume, are rather crazy. Be that as it may, though, for the summer time period, the court is going to move the time from 4 or 4:30, 7 or 7:30 to be 5, at the latest 5:30 for the summer. I'm not going to hold mother in contempt. She followed the black letter law of the order. She did. Now, this half-hour grace period is a half-hour grace period that the friend of the court and many friend of the courts recognize. I will not fault a single staff member for trying to answer a question on the fly to make sure that the parties have adequate answers and they can proceed forward. But it's going to be 5 or 5:30. Now, there is no grace period after 5:30. We'll make that clear. It's be there between 5 and 5:30 to end no later than 8:30, obviously, if it's 5:30, and that's it. So we have no issue, no question. That's what it's going to be. Any questions regarding that, Mr. Young? Mr. Reed, do you have any questions?
I have no questions, Judge, on it, but I hope it's the last modification because this is the third time since October. He makes these deals, we discuss these issues, and he walks out of there, and 4 days later, he starts showing up late. That isn't summertime.
Well, we made it very clear, I think, what the time parameters are now. When does the summertime schedule end?
It can vary. I would assume by October.
Okay, so September will be the review.
Yeah.
So we'll be into the summer schedule.
So if I'm understanding, it's the same procedure, you just extended it an hour.
Yes,
And so if he's not there by 5:30.
that's it.
All right.
That's it. There's no half-hour grace period after.
And
Now, but I will say this, though. That's the black letter law. That's the ruling of the court. However, if there is a mutual agreement between mom and dad, which is already part of the order, that's fine. But if they don't mutually agree, that's the cutoff.
So if he shows up at 5:15, it ends at 8:15, the same way we had originally agreed to.
Yes.
All right. Because there will be problems, Judge. I'm just telling you in advance. There will be.
I'm trying to be accommodating to everyone here. I want the time.
All right, Judge, thank you.
Thank you. I'll be on this motion regarding custody and other matters. Mr. McGrath is present. He's in pro se. Ms. McGrath is also present, and we just received appearance. from is Amanda Rogenbuck, representing the defendant in this matter. In light of that, just so that we're clear here, Ms. Rogenbuck, are you ready to proceed in this matter?
Judge, I am ready to proceed as a preliminary matter. I do want to let the court know, I e-filed yesterday. I was retained this week. I did confirm with Ms. Schultz. I emailed her a copy. I, by first class mail, served Mr. McGrath, but I also presented him a copy today because I knew the first class mail would not get to him overnight.
I just want to make sure you're ready to proceed.
Yes, Judge.
Okay. Well, both Mr. and Ms. McGrath, please raise your right. Mr. McGrath, this is your motion. Please explain to the court what's going on here and what the proper cause of change in circumstance is.
Judge, I know there's a couple of preliminary matters for court's efficiency that I'd like to address.
Go ahead.
Mr. McGrath has filed 3 motions. I would request that the court hear those simultaneously so we don't have to do this argument 3 times because they're all intertwined motions. And I would also request an offer of proof because there's already an established custodial environment before we move forward. Karen.
Very well. That's why I kept it very open in my question.
Thank you, Judge.
The established custodial environment will be addressed in a moment, but let's hear what's going on here. Mr. McGrath, go ahead, sir.
I just request in our divorce, divorce setting, there's a, shows that Dana has custody of our children. I'd like to change it to 50-50.
Okay, and
Not just.
What is the proper cause or change in circumstance warranting that? The court is, and you can tell me, and Ms. Rogenbach can tell me if I'm wrong, but the parties have joint legal custody, but physical custody is with the mother.
Yes, I would like to make that 50-50 as well. Now that I have a stable set home and somewhere that's mine, I would like to also share that 50-50 custody with her.
All right, well, that goes to proper cause or change in circumstance. So explain to the court why you feel that custody should be modified.
I have
And or parenting time.
according to this here, this is saying that my work schedule is, it changes constantly. That's untrue. Come through to the 21st, I will be switching to a day shift that is a set 12-hour schedule year round. So that's a change in my work schedule there. That'll allow me to have more time with children.
Okay.
Also, over the last 7 months, we've actually had more, I had more time with the children than what is put forth in our divorce decree.
And was it at least 2 overnights a
Yes.
month?
I believe it states a week.
A week, I'm sorry, 2 overnights per week.
Yes.
Okay, so explain to the court why you feel you've had more than 2 overnights per week.
If you see the schedules that I presented to you,
I'm going to object, Your Honor. It's not evidence. If he wants to testify to it and introduce it properly, he can.
Go ahead, you can explain it. It's an attachment, but just give me your version of what you believe the parenting time has been over the last, as you say, 7 months.
the parent time over the last 7 months, as you can see,
Well, I'm not seeing it.
Okay.
You tell me.
as I present, can I present this to you where I can tell you that if shown here, it's shown
You're
that,
dealing with counsel here, so I'm anticipating an objection.
yeah.
So are you offering this as an exhibit?
Yes, this is an exhibit to the court.
Judge, I'm objecting. There's no proper foundation. If you'd like to testify and go through the rules of evidence, but I have to defend my client.
I'm gonna adjourn this until I can get a lawyer.
I will object to that, Your Honor. This is his motion. He filed 3 of them. My client had less than 2 weeks to prepare. I am here fully prepared. Mr. Keenan, if Mr. McGrath wants to move forward, today is that day.
I'm ready to motion for adjourn.
Thank you, Judge.
Let's get another day. How long time frame to talk about here for an adjournment to get counsel, sir?
2 weeks.
2 weeks?
If it's 2 weeks, then it's June 28th.
June 28th.
No, Judge, I will be in Hawaii as much as I love spending time with you guys. I'm not doing this by Zoom.
July 12th.
July 12th?
I can do that, Judge.
Mr. McGrath, July 12th. July 12th. 9 a.m. The court had an opportunity to speak to parties chambers regarding possible disposition of this case. However, it appears that now. That's correct. Light of that, Mr. G, you may proceed.
One preliminary matter.
Oh.
We will call from prior hearing the adjourned at Mr. McGrath's request. I'd ask for an offer of proof because there's a request to change custody. I would resubmit that request because in our opinion, nothing has changed.
Three motions were filed separately. Both custom motion for parenting time and to support. At this time, I would agree that there is not proper cause change circumstances applied on its face in the motion regarding custody. We would abandon that at this point. Thank you. Your Honor, the judgment of divorce contemplated that parenting time would be really pursuant to my client's work schedule and availability of being able to have overnights. At the time, he was working overnights and had a few days off per week, and therefore he was unable to exercise overnights with children. He has since changed jobs. He has also obtained his own home. Because of that, he is now able to exercise really the arrangement. He does have 7 days off every 2-week time period where he would be able to have parenting time with children. And we believe that it would be in the best interest of the children to have further parenting time with him. And so we are asking the court to modify the parenting time such that he has more overnights. We believe that it would be appropriate that on his weekends that are off, that he has the children for those times, and then the opposite weeks he also has during time off during the week. We believe that it would be appropriate for him to have children during that time as well for those overnights. And we're asking the court to contemplate a parenting time schedule of that nature, and then have that referred to for court calculations.
Child support first, we are comfortable with a referral for child support, depending on what the court rules today. There's likely going to be some type of change. We don't dispute that it needs to be reevaluated. With regards to parenting time, I will advise the court, the judgment was drafted specifically to give him 2 overnights per week pursuant to his work schedule. The judgment doesn't say if his schedule changes, his time increases. If his schedule is different, his time increases. It says 2 overnights per week, period, stop. There's no miscommunication or misunderstanding as to what that means. That means a total of 8 nights per month for the course of the year. It specifically says in the judgment 2 nights per week, year round. It doesn't even allocate for summertime extensions. So we don't believe there has been a change. The children have an established routine. My client is prepared to testify. She has visual documentation of calendaring. Dad's never exercised 50% of the time. He's never wanted to. He's refused weekends he's been off because he needs his free time too. And that's great. Parents do need their free time. But if this is about seeing your children more, you'll see them on the weekends instead of going out. That's not what this is about. The children have a set routine. They're comfortable with their mother. He has ample time with the kids. He had a home before he started parenting time overnight. So buying a home versus renting a home is not a change. The fact that he wants more time and that he's now in a public safety job, if he might be on days, next week he could be on nights. He is a public safety employee who is subject to the government changing his schedule at any time they choose. We don't believe that there should be a change. I will say my client is open to setting a more permanent schedule because it's difficult for the children to go someplace for 1 or 2 nights during the week during school. It is easier in the summer. We're open to a block of time in the summer. We're open to blocks of weekend. But pulling these very young children from the house 1 night during the week overnight to then plunk them back in is very disruptive for children. Thank you.
Thank you. I would point a couple of ground rules. I don't want you mentioning your children's names on the record. You're good. And how many children do you have? 2. Sir, you had a judgment of divorce that was entered in August of 2023. Is that correct? And pursuant to that judgment of divorce, what is your parenting time?
2 overnights.
At the time that the judgment of divorce was entered, did you have your own housing?
No.
What I mean, well, did you have a place to live?
I did.
Okay, so you own that. Boys, all right, you own a home today? Children have their own rooms?
They do.
When did you purchase the home?
Everywhere.
What year? I'm sorry, Judge, I didn't hear what year you said.
I didn't hear you.
Have you been exercising your parenting time pursuant to the court order?
Yes.
Has there been difficulties in exercising parenting time at all?
Yes.
How so?
On days I have off, such as an example as yesterday, I get off of work at 7 p.m. or at 6 p.m. I do children at 7 p.m. that night and the rest of the weekend. I don't do that. Instead, I have to wait until night at 7 p.m. Sunday.
All right. You are getting your.
I am getting to overnight that is required by law.
All right. At the time that the judgment of divorce was entered, what was your work schedule?
It changed constantly. I worked overnights, 12-hour shift. I also worked a swing shift. I also didn't know what days I would be working until 2 weeks before my scheduled time.
Was that the rationale for what is contained in the judgment?
Yes.
Since that time, has your work schedule changed?
Yes.
Has your employment changed?
Yes.
And what is your current work schedule?
It's a fixed schedule over a year. I work a day shift, 12-hour shift.
Is it a 12-hour shift?
Yes.
And during a 2-week period, what would be the days that you are working?
Over a 2-week period, starting if I work a Friday, Saturday, Sunday, I have Monday, Tuesday off. And then I work Wednesday, Thursday, and then I would have Friday, Saturday, Sunday, and then I work Monday, Tuesday, and then I have Wednesday, Thursday off, and Friday, Saturday.
So I have this great. Week 1, you would, if we have Sunday to Sunday for your weeks. Week 1 would be Sunday, Wednesday, Thursday. Week 2 would be Monday, Tuesday, Wednesday, correct?
It would be, I would get out of work Sunday night at 6, kids at 7. Then I would have them Sunday night, Monday, and then return them Tuesday evening at 7.
That would be on your first,
Yes.
your first week. And if you work then Wednesday and Thursday.
Wednesday, Thursday, and then I would pick up Thursday evening at 7 and return the children Sunday at 7 p.m.
So I'm asking what days you're working on that second week. It would be Monday, Tuesday, Wednesday.
I work Monday and Tuesday. And then I have Wednesday, Thursday off, and I work Friday, Saturday, Sunday.
Have there been any issues with your parenting?
As in being, I don't know.
Objection, asked and answered. He's already said he got his parenting time, and he's already said there's been difficulty in communicating.
I'm rephrase, make it a little more clear,
Thank you,
but,
Judge.
have you had, good parenting time with your children?
Yes.
No behavioral problems or anything like that? All right, have either you or your ex-wife had any behavioral problems with the kids that you have discussed, that have been concerned?
Not particularly, there's been some things at school with our son, but we've talked through those, or I've worked with them. So I know she is too.
And just for the court, how old are your children?
7 and gonna be 13.
All right. What are you asking the court to?
I'm asking the court to grant me more parenting time.
What kind of a schedule would you like?
Basically, all the days that I have off, like to have my kids.
Are you able to transport the children to and from school?
Yes.
Any issues with that?
No.
Have you done that in the past? Have they been already or anything like that?
One time, I believe.
Okay.
Morning.
All right. Do you believe that more time would allow you to have a better parent-child relationship? Yes. Could you explain why?
My kids like spend time with me. I can be there on school days and help them with homework.
I can be there for extracurricular activities. I'll have them to take them back and forth. And my children ask why they're such.
Objection, hearsay.
Can't say what your kids said. What other matters do you think would be important for the court to consider governing your parent and your children?
Just a stronger relationship with their father. I don't understand. I don't understand why I can't have equal amount of time
Are you
with
living
them.
with anybody?
No.
If you were to have that parenting time or that schedule during the summer, would you have availability of daycare?
I make the availability, or I could speak with family members to help me with that.
Okay. Brad, how are you? All right. So I want to go over a few things. I am incredibly confused by your work schedule based on your testimony, so I don't want to be combative, but I want to make sure we have this correct. Can you explain to me in 2 weeks cycle what your work schedule is?
So we'll start with me working a weekend. So I work a Friday, I work the Saturday, and I work the Sunday. Get out of work. I have Monday, Tuesday off. I work Wednesday, Thursday. I have Friday, Saturday, Sunday off. I work a Monday, Tuesday. Or I'm sorry, yes. Work Monday, Tuesday, and then I have Wednesday, Thursday off, and then I work Friday, Saturday, Sunday.
So we're on the same page, but things confusing you too. On 1 week, you'll work Monday, Wednesday, Friday, Saturday, Sunday.
Yes.
The following week, you'll work Wednesday, Thursday.
Yes.
Are those 10 or 12 hours?
Oh.
Thank you. Okay, so your children are 12 and 7, right?
Yes.
Okay, so you're asking the court to change Jeremy. You would run or abandon the custody of the husband. Who's going to provide child care for the children when they're here and you can't be
Why couldn't I do that?
there? That's by the course of your job, sir.
I have friends and family that I can contact to take care of the children.
So my question is, when you can't be there,
Family.
specifically who, please?
I'll say my mother,
What's your mother's name?
Terry McGrath.
Can you spell her name for me?
She live in here.
Yeah, she does.
Okay, is she employed?
Yes. Part time.
Okay, is she?
She works at the school as a librarian.
Okay, and so if you're not available, she would be your backup person.
Yes.
Okay. And she's available to flex her schedule? Okay. So would you agree with me that consistency is important for children?
Consistently seeing parents, yes.
And you would agree with me at the time that you got divorced, you had a place that you were living, you maybe didn't own that place, but you lived someplace,
I
correct?
did.
Okay, so the fact that you bought a house didn't mean you were suddenly housed when you were on a house before, correct?
Well, before the housing wasn't exactly adequate for my children.
So tell me about your house, Mr. Brad.
About it.
How many bedrooms, how many bathrooms?
3 bedroom, 2 bath.
Okay, and where is that located? You don't have to give me the address, tell me. Okay, and who resides in that residence with you?
I do. My children and my dog.
I'm sorry, I didn't hear what?
My dog.
Okay. Have you ever indicated anything to the mother of your children that you are entitled to a free weekend?
I think what you're referring to is,
I want you to guess.
not guessing.
Okay.
What you're referring to is the original schedule we had set where there was 1 week out of the month that I had off that I didn't have the children.
That's not what I'm referring to, but I appreciate that, and I will ask you a better question. At any time, has mother offered you weekend time that you refused that time since the actual judgment of divorce?
Not that I can recall.
Do you have documentation that shows otherwise?
It looks like maybe I did.
Okay, all right. So your position is, it would be better for the children to have less time with their mother, to have more time on favor with you.
That's
Wait,
not
wait,
what I
wait.
said at all.
Let me finish the
I'm sorry,
question.
I'm not gonna let you.
Let me finish.
No,
Judge,
because
you
it's
can-
not.
Mr. McGrath,
I'll allow her to rephrase the question.
Thank you. Your position is you should have more time with the children, that you can send them to daycare with the babysitter or anybody you choose.
No,
Okay,
that is not what I said.
yes or no?
Your,
Yes or no? Yes or no?
Mr. Your Honor, I'm gonna object, it's actually said no.
I heard the second.
That's fair. All right, so you would agree that if the children can't be with one parent, they should be with the other parent?
yes,
That's for now, I don't have anything further for this witness, but I anticipated after my testimony. Thank you.
No, you're.
Judge, I may approach. I'm going to provide Mr. Jean a copy of the same document that I provided to you for review. It's part of the minutes for you. I'm going to ask you to review that. Do not read it out loud. Read it to yourself and let me know when you complete it. You can read it. Okay, so we're going to lay some foundation. Can you tell me what this document is? Without reading it to the court, tell me what this document is. Okay, and that is from a period of December 2022 through July of 2024, is that correct?
Yes.
When he moved out of our. Okay, and on the bottom, there's some handwritten notes. What do those notes, without reading the notes, what do they contain?
Just a mom, number of days.
And would that be the number of overnights reflected that you had?
Oh, number of overnights.
Okay, and did you prepare this document? And does it accurately reflect the number of overnights you've had with the children consistently since December of 2022? Okay, and looking through this document, you would agree that the blank spaces are the spaces that Dad has exercised parenting? Yes. Okay, so I want to be clear, in every divorce and custody case, there are some bumps in the road. Your transition from married couple to separate homes has not been completely smooth, true? But you guys are working it out.
Yes.
And you would agree with Mr. McGrath stating that you've been able to resolve some issues through talking? You would agree there's also some issues you don't agree on, like technology? Yes. Okay, so I want you to go back to the entry of the judgment, because lots of things happen during the process of divorce. Since the entry of the judgment of divorce, have you actively denied Mr. McGrath parenting time that he was entitled to? And is it an accurate reflection that your judgment of divorce says he's entitled to 2 overnights a week? Is that correct? And that's to be year-round, is that correct? And I was not your divorce attorney, correct? Right. So I have no part in the drafting the judgment, but is it an accurate depiction that your understanding is that that was to continue no matter what his work schedule? And that reflects the fact that he's in public safety at this point. And he can change agencies, is that correct? He can change schedules, is that correct? He can be held for overtime or called in for court, is that correct? You anticipated that that would continue going forward, is that correct? And that was why you agreed to the judgment, you agreed to that. So when the kids are with you, content? Yes. Happy? Do you send them to friends, families, neighbors on a regular basis to not provide, so they can provide it here? Okay. When the kids are with you and you have to work, what do you do?
My daughter attends the first network. Okay. And my son, well, they do allow him to stay home 5 hours a week. And I do for the.
Okay. So you believe that he's a reasonable age that he can care for himself and he knows how to get hold of this problem. And your daughter, you said, is in a summer school program? Okay. And then during the school year, do you work while they're in school? Yeah. Okay. So you don't utilize daycare. Okay. Do you believe it's better for the children to be with one parent if the other parent is not available? Okay. What do you base that belief on? And it's a true statement that you've discussed the desire to have some consistency with the kids. You don't think it's good for them to bounce around 1 or 2 nights during the week, correct? No. Okay. Let's talk about what you think would be good for the kids. Dad is entitled currently to 8 nights per month, correct? Yeah. Okay. Are you comfortable with them? Let's say Dad now has 2 weekends. Are you comfortable with them having an alternating weekend with Dad, say Thursday through Monday? Yes. Okay. Are you comfortable with on the off weekend one, them having what we call a dinner after school till 7 or 8 o'clock at night? Okay. And is that tell me why you're comfortable with the dinner break, but you'd rather than not be an overnight.
The time of the dinner after school would be okay. However, I would like them to stay on the same routine.
Okay. Are either of your children particular about routines? Okay, so tell me what happens when your oldest child, so you heard Mr. G, we're not gonna talk about names, although the attorney sometimes gets, we've done it for years, but we're not gonna talk about names. Your oldest child, does that child have any proclivities or issues that happen when his or her routine is not?
He just needs it. Yeah.
I'm keeping a routine. He needs sleep. He needs.
Okay, so for him, schedule is important. Okay, your youngest child, any issues there if the routine is thrown off?
A little bit more flexible with her. So again, she needs.
So having 2 weekends of 4 overnights, which gives them 8 days, and 2 dinner breaks in the off weeks per month during school would allow the kids consistency and contact with that, is that correct? Yes. Okay. Are you opposed to having alternating weeks in the month? Okay. And you understand that would be 6 p.m. school recesses till the Friday before the school resumes at 6 p.m. And you again would just switch every week, Friday to Friday. Okay, and you're comfortable with that? Yes. And you would like the court to keep all other conditions in the course, is that correct? Okay. Judge, I would ask that defendant's proposing that it one be a motion.
I would object to the calendar from December 22 through August of 2023, since for the last quarter. And I don't think that it would be relevant to the determination of modification of the last quarter. Thank you. Other than that, no objection.
No objection, Judge, we'll reduce it. I'm happy to have the court take it out, but Ms. Sarah marked the December page, so I'm gonna leave it all together and then have to remove that sticker, so I'm not.
They'll be accepted, court will accept this one basis.
Thank you, Judge. So to be clear, you're not trying to keep dad from parenting time? And you believe routine is consistent for the kids? And you would be comfortable with 2 extended weekends, months during school break? And after school visit on off weeks? And alternating weekends in the summer? Okay, you believe that's in the best interest of your children? And just so we're all clear, you're comfortable with referring whatever judge does to down to the court, because there's investigation to do some work, correct? And that would be for an investigation in child support. And you were comfortable with the fact that they've abandoned their claim for custody. Thank you. Nothing further this time, Judge.
Good morning, ma'am. I just wanted to make sure that we are clear on this issue. You are not trying to keep the kids from their father at all, correct? All right, thank you. You believe that consistency is important, yes? You believe that it is important to the extent that the children have a set schedule and they know when they're going to see dad and when they're going to be with you? Would you agree with me that the consistency that you're talking about substantially rests in a schedule for the children that they are unaware of? Correct.
Yes.
So when we're talking about the consistency and them having that consistency, you said your 13-year-old has kind of a need for good consistency in order to maintain school and all the other activities that are going on, right? All right. The younger child is a little bit more flexible, I think you said, right? Excellent. Usually that will happen with those younger kids. As it relates to the consistency, it is true that the court order indicates that Mr. McGrath has parenting time 2 overnights per week, correct? Those 2 overnights fluctuate as of now, correct? And that has been going on since the judgment of force was entered, true? Now, would you agree with me, ma'am, that the 2 overnights per week since Mr. McGrath has changed his work schedule have been largely dictated by when you agree to have the kids go over that? Do you not agree with that? Okay, so let's back up for a moment and we'll set some groundwork here. Mr. McGrath before had 2 nights that he was off
I'm gonna object just for clarification before what point in time.
before he changed his work. Thank you. At his old position, he was working overnight and had 2 days per week off, correct? Okay, the judgment of divorce made it pretty clear for parenting time that the plaintiff shall have parenting time 2 overnights per week year round based upon plaintiff's work schedule and as agreed by the parties. Yes? And so that particular schedule was being exercised. Yes? It was inconsistent insofar as neither you nor Mr. McGrath had a really good idea of which 2 overnights those would be. Isn't that fair?
No.
Okay.
Here's my grant would provide me a calendar of his availability. From there, we choose which day to be consistently every other Friday, Saturday,
Sure.
or Monday, Tuesday.
Sure.
So take the calendar that it was scheduled for the children.
Of course, and I appreciate you clarifying that for me. Let's just kind of break that down a little bit, because before, when he was at his other position, those particular days were not set days. They would change when the schedule would come out, and that would come out about 2 weeks prior to the day, correct?
When did you work for the county?
Right. So every 2 weeks, he would be sending you his next schedule, so then those overnights would be planned, correct? All right. So we have the inconsistency that you've already described from his prior employment, and now his employment is more consistent, that he has a set schedule, as he's indicated, for a 1-year time frame, that it would be the schedule he gave us during his testimony, correct? All right, so now you know that his set schedule is what it is for the next year on a 2-week time period. And you have been still following the court order, the 2 of you have been following the court order that he has 2 overnights per week, correct? And part of this whole idea that he's denied the weekend parenting time is he's asked to have the kids on his off weekends, correct? Sure, he is asked to have the kids on his off weekend, correct?
Yeah.
And one of the issues with him asking about that is that he may have had another overnight during that week. Isn't that true? And so you told him that you wouldn't allow him to have that overnight because that would exceed what the court order was.
I never said he was not allowed. I did not lead to the additional overnight that we were following.
Sure. Phrasing it that way is perfectly fine, but the court order does also say that it is based on his work schedule and as agreed by the parties, correct? All right. And so your position is that this isn't you denying, it's just you're not agreeing. Is that fair?
Objection, asked and answered. She already answered the question.
Did, but I was gonna ask the same question, so objection.
He was getting every other weekend and an additional day every other week to meet the day. Getting 3 days.
Okay.
Every other weekend, and then an additional day.
All right. Is it your position that the children are going to suffer in some way if they spend more time with their father? Right? You've indicated that you want consistency. You don't want the children bouncing back and forth. Yes? All right. Would you agree with me, ma'am, that if they have a set schedule that they know that week 1 they'll be with you on Tuesdays, Wednesdays, Thursdays, week 2 they'll be with dad on Monday, and they'll be with dad on Tuesday and then the weekend, that would be pretty consistent, would it not? Sure, and just to clarify the question and make it a little simpler without having to get out a calendar, if the children have a very set schedule for the next year that is on a 2-week schedule, right? So the same exact days they're with you, the same exact days they're with dad on a 2-week schedule, and that is consistent throughout the year. Would you not agree with me that that is consistent? Okay. You've also indicated that you make arrangements. I'm sorry. You indicated that you believe children should be with one of you when one is not available. That has children, right? Is that a yes?
Yes.
Sorry, because everything's being recorded. We need to have yes and no. No worries. And so, for example, if Mr. McGrath were working, you believe the children should be with you, so they can be with a parent rather than a third party. Is that correct?
Overnight during the day at time.
I don't know, because I guess you have a position on that.
Right now we have first overnight.
Right. And is that what you're wanting to keep?
Yes.
Okay, so to be clear, it isn't a problem with you then if Mr. McGrath has the children, for example, during the summer they're not in school, he's working, he has to have a babysitter. That's perfectly acceptable, yes? Similarly, I mean, you indicated that your daughter is in a summer program when you're at work and your older child is at home alone because old enough to do so, yes? Okay, very good. Would you acknowledge that the exhibit that has been admitted shows that throughout the course of the year from August of 2023 through now that Mr. McGrath has been getting more than 8 overnights a month?
Roughly 10.
Okay, all right. He's only technically entitled to 8 though, correct?
2 overnights.
Okay, all right. And so then you would agree that the two of you have been able to work out where he has had more parenting time, where it is available for him to exercise, yes? Okay. So would I be correct then in saying that your contention with this request really lies in him having I guess what we would say a joint arrangement or 50-50 parenting time?
I mean, that's for clarification, so that way I'd like to define what he means by 50-50 parenting time.
Sure. Your contention here would be that you don't want Mr. McGrath to have equal time with you. That's what you would guess.
I believe his schedule is truly consistent for equal time. They would be bouncing back and forth every couple of days.
Don't you think it would be inconsistent or inconvenient, I suppose, if I can use the word, for your children to be able to have quality parenting time with their father while also accomplishing things like homework and getting prepared for the next day, if during the middle of the week that they are with you, that they have a dinner with their father? You don't think that that would be disruptive to their ability to do things like homework and get things accomplished for the next day?
No.
Okay. Could you explain to the court why it is that you think that that would be okay for him to have a couple hours with the kids on, say a Wednesday of his off week, and that would not be disruptive to the kids, but if the kids stayed overnight where he isn't working, that would be disruptive?
I believe a dinner would be okay, quality time with the children, but it disrupts their school routine.
Well, how would it disrupt their school routine if he's still doing the homework with them and he's still getting them to school?
Starts their school. They're leaving one house, they're leaving them in another, then they're leaving home, and back to a different house. It's disruptive during the school routine. And issues already.
Okay. Would you agree with me that the issues that have been coming up with the older child are substantially related to the fact that the parenting time has not been on a set schedule that is basically a permanent schedule?
No.
You don't disagree, or you disagree with that? I think that is the issue.
No.
What exactly is the issue?
He has a hard time his relationship with his mother is a little bit more difficult, I think, and he transitions harder from it.
I see. So would you agree with me that that particular concern exists if Mr. McGrath has the children on, say, a Thursday night going into a Friday, taking them to school on Friday and then taking them to school on Monday?
I'm not even sure what he just asked my client, so I'm sure she has no idea. I just don't know what he asked. I'm just asking a clarified question.
But I can, sure. So you believe that the big problem with having these overnights during the week is because of this relationship that you described between your.
Objection, asked and answered. She's already answered that stability is the reason that overnights during school.
I'm trying to clarify.
Yes, objection.
Thank you.
That a lot of this has to do with the relationship with your eldest child, Mr. McGrath. Okay. What confuses him exactly?
That he has been talked to about information that he should not know.
Okay. Are you referring to the court case? Scheduling. Okay. Well, is there anything else that you think is an issue? Okay. All right. So we have an issue over scheduling. Would you agree with me, ma'am, that having a very set schedule that is not changing, it's pretty rigid, would assist with that?
Yeah, should have been.
Okay. But again, my question is, do you think that if the schedule was rigid and it was consistent, that that will alleviate that concern that you have? All right. Very good. To be clear, you don't think that Mr. McGrath is a bad father, correct? All right. Would you agree that the two of you have difficulty communicating? All right. But despite that, the two of you have been able to work things out for the betterment of your children. Is that fair? All right. Very good. Thank you, Your Honor. And nothing else.
Thank you, Judge. Ask you to review that, now, I want you to go forward to August of 2023. We're only going to talk about August of 23 forward, okay? How many overnights did you have August of 23? How many overnights did you have September of 23? 19. How many overnights did you have October of 23? 19. How many overnights did you have November of 23? December of 23? January? Okay. So I was going to say your overnights compared to that are about 2, correct? Okay. Mr. Jean was talking about having a gradient effect. Remember that conversation? Okay. Is your concern that having your child spend the night someplace else?
Objection, legal.
Or rephrase it. What is your concern about your child going from one house to the next for night and then back?
I think it throws them off. I think it starts to explain that.
When you say it throws them off, explain to the court understands as their mom what your concern is.
I think it affects their school. I think it affects their behavior.
How does it affect or how does it affect their school?
I think having teachers, behavior, emotionally, and yeah. It throws them off in school. They don't know where they're going. They don't know who's picking them up, if they're on the bus, if they're not on the bus.
So let's explain this so the court understands your concern. There's a difference, in your opinion, between dinner break and an overnight. What is that difference?
All the time with their dad for a few hours after school.
Okay, so to be clear, it's not seeing that. It's not being in their typical bed, not being in their typical routine, and then having to function the next day. Yeah. Okay. And to be clear, you guys have been able to agree on additional days for him, is that correct? And the calendar reflects that you've done more than the bare minimum of 8. And it's always been your understanding that if you can agree to more, that's exceptional and wonderful. But you would rather not sacrifice your time with the children? You would not sacrifice the stability of the children? I have nothing further for this time. Thank you, Doug.
I have a question. For the proof.
Actually, I'm gonna call Mr. McGrath.
For the witness stand, you still hear us.
Mr. McGrath, you're aware that the judgment of divorce grants you 8 overnights, correct?
Yes.
Okay. And you would agree with me based on the evidence presented, you generally exercise more than 8 overnights?
Yes.
Okay. Would you also agree with me based on the evidence presented that moms exercise more time?
She said.
Yes. Okay. I want to talk about your work schedule. We've got the days figured out. How long will you be on your current schedule? So your schedule can never change.
Unless I promote.
Okay, so you hired in on this Monday, Tuesday, Friday, Saturday, Sunday, Wednesday, Thursday, alternate weeks. And from now until, I'm sorry, how long have you been at police officer? For the next 25 years-ish, you will be on that schedule.
As far as I'm aware, yes.
And does the city bid slots like day shift, night shift, afternoon shift?
No.
How do they assign?
Seniority.
And how many people are in your department?
Overall, as well, what positions?
The position that affects your shift placement.
4.
What number are you? 1, 2, 3, or 4?
2.
Okay, so there's somebody above.
Yes.
All right. I have nothing else. Thank you, Judge.
Virginia?
No.
I think that the testimony is clear and it meets the standard pursuant to Shea versus Wright for a modification of parenting time. I would further indicate that I do not believe that the modification of parenting time such that the parties would share what would virtually be a 50-50 arrangement would run afoul of the Von standard, because I don't believe that there is a modification of the custodial environment. Certainly, if there were a modification of the custodial environment, Von would apply, and then we wouldn't be able to move forward with any sort of modification to that extent. But I do believe that the custodial environment lies with both parties. The children, the parties have testified that the children look to them as they would their parents. Although we didn't have an extensive testimony on this issue, I don't think there's anything that would say the opposite, such that the court could not find that there isn't a modification of the custodial environment moving forward with the proposed arrangement for parenting time. We believe that it would be appropriate for the court to issue an order for the parenting time to be such that my client would have the children on the days that he is not working and having those overnights. Frankly, I don't think that it's a genuine or justifiable argument to suggest that the children need some sort of consistency, which they don't have now, but it would somehow be inconsistent and difficult for them if they had this permanent schedule, knowing where they're going to be and having those overnights during the week. Even when the court looks at the exhibit that has been admitted, the children, for the most part, have been going to my client on weekdays while they are in school. There was no testimony that the children's grades were somehow slipping, that there were other issues other than this, this nebulous claim that there's these behavioral issues with emotions. The fact is, my client testified that he doesn't have any issues with kids, doesn't have issues getting into from school and everything. That has been going on. If there were a large concern over that, I think what we would be seeing throughout that exhibit is that he would have more weekends to avoid that kind of disruption. So I just don't think that's a genuine argument to say that he should not have overnights, particularly during the week. Couple that with the fact that there doesn't seem to be a problem if the children are with him for this dinner time. And the fact of the matter is the difference between the two is they're sleeping at his house versus sleeping at her house. There hasn't been testimony that that's inappropriate in any way. And so the reality is that the consistent schedule would do the children good. It wouldn't be detrimental for them to be with my client during that time. It's been testified that he's able to do the homework, that he has done those things. He's had the children in that capacity, and by all accounts has had a perfectly fine routine. There's been just the inconsistency of the days. And I think with his set schedule, that can happen. There's been no argument that he's not a good father or he doesn't love his children or anything like that, other than this testimony that he somehow said something about the schedule. Well, the reality is I'm sure a 13-year-old is talking about the schedule, saying, when am I coming?
Objection. Hearsay, you can't argue what the child would have testified to. The child's not here, and the court's already ruled that dad can't testify. Mr. Jean is certainly not allowed to testify to what the child may or may not have said.
Thank you. So we do believe that we have met the proper standard under Shade versus Right, that it doesn't change the custodial environment, and therefore the court can order a parenting time schedule as proposed by my client. And we are asking the court to do that this afternoon. Thank you.
I would indicate to the court that it's my client's position that the modification that Mr. McGrath is asking for absolutely does change the custodial environment. Unrefuted testimony, the exhibit was unrefuted, and Mr. McGrath acknowledged on record that she had approximately 2/3 of the parenting time, he had approximately 1/3 of the parenting time. That is a substantial change. There was unrefuted testimony that children struggle to go back into a routine after being bounced from one house to the other during the school year. Mr. McGrath has exercised roughly 10 overnights since the entry of the judgment on divorce per month. My client is happy, as we said in opening statement, as we talked about it in testimony, she is happy to have a set schedule. She is happy to share something, but during the school year, the children need that consistency. Mr. McGrath can exercise the quality time he's looking for and still have substantially more, 5 weeks or 6 weeks in the summer is an extra 42 days from what he has. He's indicated his schedule will never change. He might actually be the only police officer I've known in the last 30 years whose schedule never changes. The parties have been able to work through most issues. The court has heard that. My client has agreed to more days than she was required to. She has worked with him at every turn. Her concern is the consistency for these children. She would ask that the court adopt the following. If the court is not inclined to continue the current order as presented, then in the alternative, either 10 overnights per month year round, or my client would ask for the following. I will go slow, so I apologize. I know it's not fair. She would ask for alternating weekends, alternating weeks during summer, 6 p.m. Friday to 6 p.m. The following Friday. Thursday through Monday, dad picking up after school Thursday, dropping off at school Monday morning during school, 2 weekends a month. A supper break on his 2 off weeks during the school year, so Tuesday, Wednesday, Thursday, whatever night after school till about 7:30, to continue the first right of refusal, and then to be clear, to refer the child support recommendation down to the front report, and for the record to deny the custodial change of motion being allowed to abandon. Thank you.
Insofar as this request that it's 42 days more than what he has now, the fact of the matter is it's not 42 days more than what he has now, but for on paper, because as the exhibit clearly shows, my client has been exercising more time than what the judgment gives him. And to the party's credit, they have been able to agree on that. But ultimately, we're talking about, if we were looking at the consistency from what the schedule has been for the majority of the time since the entry of the judgment of divorce, we're talking about just a few more overnights per month for my client. We get to that 14-day time period. We have many months here, as the court can see, where we're pretty close to that already. And so I think to suggest that this alternate schedule where it's week on, week off in the summer somehow just gives him more time. I mean, the fact of the matter is that it wouldn't, because the proposal puts him back to a 8-day of the month overnight schedule during the school year, which the parties haven't been following. So I certainly think that granting his parenting time on the days that he is not working certainly would be appropriate. And I don't think there is anything here to suggest that it is a substantial change, particularly given what the parties have been doing. So I'm asking the court to do that. Thank you.
First issue is regarding the motion to custody. It was told essentially by the plaintiff in this matter. The court finds that there is no proper cause of changes, regardless of that, for changing custody. So that's the regarding parenting time. It's a relaxed standard under Shade versus Right, and the court, when it comes to standards for the court to consider, and still has to be proper cause or change in circumstances. The divorce judgment that was entered on August 4th, 2023, contemplated the plaintiff relative to his employment. There's no question. If you look at the language within the judgment, clearly focuses on the fact that again, based upon the plaintiff's work schedule and as agreed to by the parties. Well, that contemplates not only the schedule, but the work that is involved. He's a public service. And we can take judicial notice that prior employer, and it's even reflected in the actions that the court was not supposed to look at, but when you have a schedule that is not consistent, that's what happens. You lose parenting. And that's what happened in this case. Now, moving forward, though, there is a consistency. According to the testimony of Mr. Pratt, he testified that on week 1, he works Monday and Tuesday, he's off Wednesday and Thursday, he works the weekend, Friday, Sunday, and then in week 2, Monday and Tuesday would be off, Wednesday, Thursday would be on, and then Friday, Saturday, Sunday off. This continues. He is number 2 on his list relative to seniority, and he has essentially fair to say, the best schedule he could have relative to children if you work during the day. Now, contemplating the judgment contemplating the employment of the plaintiff clearly indicates that there is a change in circumstance. There was a change of employment by the plaintiff. In this case, he went from one agency to another agency, providing a consistent schedule. The divorce judgment contemplating that or finds a change in circumstance. Now, what does that mean moving forward? Father is requesting at this point that all his days off, he would have the children, and mom's, and then when he's working, mom would have the children. The divorce judgment also indicates that parties have joint legal custody, but with mom having physical custody. That's what it states in the judgment dated August 1, 2023. The court will refer this matter to the front of the court for a recommendation regarding parenting, obviously support. In the interim, the court will order at this point is that the party shall have parenting, father shall have parenting time, as he's not the primary physical here. He shall have parenting time on alternate weeks during the summer. And this will continue until the school year begins. It just shows and explains to everyone how that works regarding when the children are to be returned. In the interim as well, once the school year begins, hopefully we have a recommendation before that. But in the meantime, if we don't have a recommendation in order to enter, the court will order in the interim that father shall have parenting time with the minor children, which would be, I would call his week 1. He's off on Thursday. He shall have the children Thursday after school. And that will continue all the way through till Monday morning. And he is responsible to pick up children during the school year on Wednesday.
Judge, on Wednesday or Thursday?
I'm sorry, Thursday. I apologize. Thursday. And he is responsible to take the children to school on Monday morning. On the off weeks, mom had discussed the idea of it'd be great to have dinner, get homework done, and get all that. And that makes sense. He also testified, though, it's still consistency, keeping consistency, and that seems to be the primary issue with mother. Court will order on the off weeks that father shall have overnight parenting time on his off week on Wednesday. After school, he shall pick up the children. He shall pick up the children. Well, wait a second. He works until 7 p.m. Right? 6 p.m. 6 p.m. Wednesday at 6 p.m. for one overnight. If the Wednesday does not work, then it will be Thursday. But Wednesday will be the primary day. That will continue while we wait for a recommendation from the Friends of the Court regarding these matters. Regarding the right of first refusal, at this point, relative to the testimony presented here, the court is striking that relative to alternating weeks, summer. But during the school year, the right of first refusal will be allowed, or that will continue. Now, that provides Dad, technically speaking, and I saw the calendar, it's about 10 days, but it allows Dad additional time, but most importantly during the summer. And we'll just try this on an interim basis until we get the recommendation. This shows regarding the issue of the week to week, and that is again prior to the school year. I'll be the next one.
Good night. First inquiry, Judge, is the court also ordering that the department participate in our as it relates to summer break, it may depend on what the court is ordering for the week to schedule. Historically, under our parenting time guidelines, our week-to-week ran Sunday at 6 p.m. to Sunday at 6 p.m. But listening to testimony of parties, it appears that perhaps a Friday to Friday schedule.
Right, I heard mom say that.
I just confirmed again with my client, Judge, that seems to be the pattern of what they've been doing, Friday at 6 to Friday at 6 for the alternating weeks.
No issue with that.
Pardon me?
No issue with that, Your Honor.
We would just need to determine a baseline date for Mr. McGrath to exercise his today, start the week from today. But summer break parenting time ends the week prior to school. I don't know that North Huron's schedule for next year has been released yet. My understanding is that most of our learning districts will be looking back approximately the second to last week in August, around August 20th.
I would ask the summer parenting start, my client this evening. This is his weekend off, and I think that would make the most sense.
No objection, and to answer the front of the court's inquiry, these has been released. I don't have it yet, but North Huron's schedule has been released. I just want to answer 2 points of clarification for the order. You indicated Monday morning is alternating weekend, those long weekends. If there's no school, will the friend of the court advise the parties as to when pickup should occur?
There is.
Wait, is it normally? Yeah, I don't know. If there's no school on a Monday morning. But again, I would still refer to the court's preference. If something better works for their family, then they absolutely.
The judge can meet as the parties agree, if not agree, then 10 a.m.
That's fine. Ma'am.
Mr. Gino, yeah.
No, Your Honor.
One more point, Judge. Yes, thank you. So you said Wednesday is the preferred, Thursday if it won't work, so we don't have any issues going forward. I want to set them up for success. And you're saying if Wednesday doesn't work, does that mean if there's a work conflict? Or does that just mean if it doesn't work in somebody's social calendar? I want to be clear.
I want to give the parents the ability to communicate.
Okay.
One day better than the other.
Perfect. I appreciate
Only
that.
reason for it.
So preference Wednesday, Thursday the fallback. Thank you, Judge. Will Mr. Jean be prepared in order?
Ready?
Thank you.
I will do that, Your Honor. Thank you.
Thank you, Judge.
I will require that the order be prepared. Derek J. Heathsman versus Corey Hill, later Balkenburg. We have a bunch of. This is the defendant's motion regarding school district, parenting time, and domicile. Ms. Heathcote, the plaintiff, is present. She's in pro se. Mr. Van Valkenburg is present in the courtroom, represented by attorney Brian Jean, who appears via Zoom. Oh, I'm sorry, I had it wrong. Ms. Heathcote is representing, or Mr. Jean is representing Ms. Heathcote. I'm wrong. Well, actually, yes, that's why. Plaintiff's response was filed yesterday by counsel. Court read the file yesterday morning. This didn't get into the court file a little bit later. All right. Mr. Jean represents Ms. Heathcote. Mr. Van Valkenburg, this is your motion, but before we do so, would you both please raise your hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Mr. Van Valkenburg, what are the issues that you are raising to the court at this time?
At the moment, Your Honor, we have changed our domicile to a new home in Fort Sanilac. Ms. Heathcote is
It used to be in
Lexington. Yes, so we sold our house in Lexington.
So you moved a little north.
Yes. Ms. Heathcote is not in agreement with our son, who is 13 at this time, changing school districts. As dictated by a court order, it was said that as long as he stayed within a school district within Sanilac County, and that we agreed upon. So I have one of those. It's also in the order regarding Ms. Heathcote's domicile, where she has moved more than 100 miles beyond the original address that she had filed the court order with the court.
And that was Harbor Beach, correct?
Yes, Your Honor.
Okay. Did you measure it as the crow flies, or did you measure it in actual miles to travel?
I use I believe there's a distance calculator on the Huron County front of the court page. That's what I use to calculate the distance. I don't know how that is calculated.
And you came up with over 100 miles?
It's 108 point something, I believe.
Because I did the calculation and it came out to around 76.83, if I'm not mistaken.
Is that to the Flint address, John?
Yes.
Okay, I just put it into the distance calculator on the website.
And I just interrupt for a moment. Michelle, on the website, is it the same one that?
I believe it is the distance calculator that the court normally utilizes.
Under resources and helpful information.
It's under custody / domicile.
There it is.
And I have a flight mileage of 76.2 miles, a driving mileage of 107 miles.
It is the same one I use. Okay. All right, so we have the domicile issue that you raised. And any other issues, sir? I believe you said something about parenting time.
Just that if the court had found it, the domicile to be outside of the 100 miles, that amount of distance just solely on the Thursday overnights has affected the minor child's grades, his attention while he's at school. This year in particular, because I believe Ms. Heathcote moved sometime last year, which I was not notified of. I do not believe the court was notified either at the time. And so all of last year when she was driving back and forth with him from Flint, his grades have decreased. He's had multiple missing assignments. He's gotten more disciplinary actions at school. And I'm just worried that with the Thursday overnight, when we move to the new home in Port Sanilac and he goes to Clarksville, Port Sanilac schools, that the distance will be greater. So I'm just asking that the court take a look at that, maybe amend it so that the Thursday overnight, instead of it being overnight follows, that she can pick him up from school, spend time with him, and then drop him back off Thursday night, so that he doesn't have to make the long trip.
We'd have to make the long trip on Thursday, though, would he not?
Well, that's what I'm saying. On Thursday, if she picks him up, because I think the standard court order is that she picks him up on Thursday, spends the time with him, and then drops him back at our house. There's no overnight. So he wouldn't have to make the long trip from Flint back to Carsonville or Sanilac on Friday morning. It would still put the driving on Ms. Heathcote, but it wouldn't put it on the minor child.
So what is the current parenting time order during the school year?
During the school year, it's every other weekend, as well as one Thursday overnight, alternating, so 2 a month, until Friday morning. And she drops him off at school, picks him up from our house Thursday night at 6.
And you want to remove the Thursday?
No, I don't want to move it. I just ask that we follow the standard guidelines by Huron County, which is she picks him up Thursday night, spends a couple hours with him, I believe it's until 8 p.m. And then drops him back off so that he can avoid that long drive from Flint.
So mom coming up to,
yes,
is what you're saying? And
she does right now. She still drives to get him, and then she drops him off at school on Friday morning. I'm just concerned for, because this year in particular, he's had a lot of missing assignments. I've had his first hour teacher tell me he's sleeping during.
Objection, you're saying?
But you believe it's causing an issue for the child?
Yes, and I do
How
have
old is the child again?
He's 13, and I do have documentation of all his missing assignments, I believe, all the way back until the beginning of this year.
All right, let me hear from Mr. G. Mr. G.
Thank you, Your Honor. As it relates to the domicile issue, Mr. Van Valkenburg is simply incorrect. The address that my client had on file immediately preceding her current address is 91.8 miles using the fastest route, not as the crow flies. As the crow flies, it is 67.69 miles from her immediately preceding address. Assuming, for purposes of an argument, that the court were to use the original address that was on file when the matter was first filed, 12 years ago, the distance would be 76.14 miles, both well within the 100-mile rule. I would also point out, as it relates to this request of Thursday being eliminated, the Thursday overnight being eliminated, the distance between what has currently occurred and what would be occurring is about 15 minutes difference in terms of a drive time from her current address from her previous address. So hardly a hardship on the child when we're looking at 15-minute difference. As it relates to the schooling issues, the modification of school, two things. Number one, I think if there's some issue here, I think we need to have more than just this simple request and no further evidence. I think the court would need to have quite a bit more evidence to make the determination whether the child should be moving schools. But beyond that, the child's 13, going into high school pretty shortly here, and has been in this current school district the entire time. And so ultimately, we're talking about the difference between defendant living right next to the school and being 20 minutes away. Furthermore, I would dispute the claims the defendant makes regarding the child's grades, tardies, etc., as being the fault of my client. I would like to see the proof of that. We've already done our homework here, and it looks like it's actually not accurate.
You objected to seeing the proof, Mr. Gene.
I'm sorry?
He was offering to provide information regarding school records.
I understand that. I'm only saying that I believe that the proof needs to be viewed by the court. But for purposes of the motion today, I think the most appropriate thing would be for this matter to be referred to the front of the court for investigation and report.
All right. Well, I think I can make it a little bit simpler. But before we do that, I'm also asking again your motion, sir, where you had stated that mom is not complying with app close.
That was just to state that I had not been informed of the address change, Your Honor.
Oh, okay.
Because it was stipulated through our order that any address changes would be conveyed to both parties through app close, whether it was myself or Ms. Heathrow that changed.
The other thing I'd like to know from mom, Mr. Gene, is if the child goes to school Friday morning, when mom had the Thursday night, what time does the child have to get up?
We get up at 6:30 and we leave the house at 6:50 and we're to school by 8 o'clock. I've never had him to school tardy or absent ever.
Now, when you were previously in Harbor Beach, what time would you have to get up?
It would, when this order began where I drove my child to school on these specific days, it had been known that I lived at 30. And when I lived there, I actually used to drop him off at the bus because I had an employment difference. So we actually woke up at about 5:45 so that I could get him to the bus stop in time for the bus to pick him up. So now with my employment change, I just drive straight to school.
Well, I'm going to make a ruling regarding the domicile issue. Clearly, there is no domicile issue. It's 100 miles as the crow flies, and actually, my calculation was 77.63, which is clearly under 100 miles. So the motion regarding domicile in this matter is denied regarding the father's request. Relative to the parenting time in this matter, what I would like to do is have an opportunity to speak with the 13-year-old, with the friend of the court, regarding the school. Now, it would stand to reason, common sense, that would be if dad moves to the Carsonville Port Sanilac district, that it would make sense that the child attend that school district because it's right there and it's going to be easier for the child, at least for travel. However, if this child is starting high school and there are ties to the other school across Lex, both excellent schools, I'd like to hear from the child regarding the child's reasonable preference relative to that. Is there any objection to the court speaking with the child on that issue? None from us.
The only objection I would have, Your Honor, is not so much in speaking to him, but also that the court take into consideration that I have 2 other minor children with my wife that will be attending CPS. And my one son has disabilities where he attends ISD in Sandusky. because the child lives with me full-time, has domicile with me and has his entire, school career, I just ask that they take that into consideration. And I also have other directions for which our family goes, and to make that amendment where I drive him to school every day because the bus does not come, from Croslex to where we're at. I ask that, we keep that in the rotation of thought too.
Oh, absolutely. The child, me speaking with the child in front of the court, speaking with the child is just one of many factors the court would consider. But I'd like to hear from the child. And I'm assuming being 13 years of age, this child is able to speak and give their respective position?
Yes, sir.
Okay. Any objection to that, Mr. Jean, on behalf of your client?
Certainly not, Your Honor.
Okay. The parenting time matter will be taken under advisement. We've addressed the domicile issue. The school district matter will be also taken under advisement. So allowing the court to speak with the child. And let's see, where is the child now?
He's currently at my home, with my partner. I have no idea what's going on today, so.
Okay, well, I'm just trying to save both parents travel time.
Sure, I can call him and have him brought here at any moment if that's what's most convenient for you.
What about the thoughts of having a Zoom meeting?
I don't think that would be an issue. I've had the opportunity to meet H previously. It's been a number of years. But he's a lovely young man. And I don't expect that has changed. So I think it would be
Your Honor, if I may too.
Sure.
Am I able to enter in the letters and the proof from the school as well?
You can submit whatever you wish to submit, subject to objection by counsel.
Okay.
So anything you want to have the court to consider, because we're going to have a second hearing on this, obviously. So at the second hearing, if you have anything, I would highly encourage you to share that information with Ms. Heathcote. Could be providing it to Mr. Jean. Well, actually, just prefer, Mr. Jean, that it be sent directly to you.
Of course, yes.
Okay. So, Ms. Heathcote, if you can provide Mr. Van Valkenburg your attorney's address and information, so that all that information can be forwarded.
Absolutely.
And when can we reconvene? Are we talking 30 days, 14 days? What do you think?
Whenever is truly most convenient for the court, I am totally pliable with
Van
scheduling.
Valkenburg.
I believe the only date that I'm going to be available is the 27th of this month. Other than that, I don't.
So let's renotice this to what date? I'm gonna let everyone else schedule that, because let's do it via Zoom. I think that'd be easier. I don't want to have the child travel all the way up, whether it be from Flint or Carson. It's still a distance. I'm trying to save you gas time and money. Unless you want me to meet with the child personally, I'll meet with the child personally. It's up to you. I'm Andy.
I think he's entirely capable of Zoom. He has a computer in his room at home, so he's more than happy to use Zoom. But if he has a preference one way or the other, I also have no objection in any way, shape, or form of him speaking to you in person.
Your Honor, my preference would be that the court speaks with the child in person. While I understand the concerns regarding the travel and gas, frankly, there's always the potential for concerns that the child could somehow be influenced off screen if it's a Zoom meeting. And just to make sure that we don't have any potential problems or any appearances of impropriety, I think the best would be for in person.
So can we go with June 26th?
Can we meet with the child on June 26th? That is a Wednesday. Is that your?
I would have to pull open my calendar. I believe it's mine. So every other week right now for summer, and I believe he'll be with me. And that is totally fine. I can bring him up. June 26th.
June 26th at
10 a.m.
10 a.m.
10 a.m. Perfect. Thank you so much.
Now, here's the thing, and Mr. G made reference to this, and I want to make it clear. H is probably an extremely bright young man, but he need not be influenced regarding how to speak, what to say, other than the truth. And so I want to caution both parents that you can tell them that, yes, you're going to be meeting with the judge and with either Ms. Schultz or Mr. Holdwick. They just want to meet. That's it. No coaxing, coaching, anything like that. Then the court can listen to the child and hopefully the child will feel comfortable. And when you spoke with H a number of years ago, was he comfortable back then?
You're very, very lovely young man, open, honest, I don't know that.
Wonderful. I don't think that would likely change. So I can tell both parents care for their child. All right, so we have the date, June 26th, 10 a.m.
And then we'll reconvene July 12th.
July 12th at 9 a.m. That's acceptable to both parties.
Yes, yes. It is actually that I'm already in front of you on that day, so that's perfect.
Okay.
And we'll send out notice. Thank you, everyone. You're both free to
Your Honor,
go.
there was one more issue today. Friend of the court had received a denied parenting time complaint from Mr. Van Valkenburg regarding Easter weekend. And the friend of the court had sent a letter out with our findings on that matter just on June 7th. Mr. Van Valkenburg had objected to our findings and was asking that it be heard before the court. So I'm just asking, is the court wanting to hear that today or hear that on July 12th? We come back on all of that.
What do you want to do, sir?
Well, actually, Your Honor, as Mr. Holdwick said, I didn't receive a response until June 7th. I just stopped in and asked if they had responded on it. Ms. Schultz had said that Mr. Holdwick was still looking into it, but he was out of the office. I said, that's fine. I said, I just want to make sure if she hadn't responded in her 21 days, that I didn't miss my 28 days after that, and that the time frame still worked out. As far as that goes, I believe, you know, that they found that it wasn't a loss of parenting time, which I am fine with. So I don't believe we have to convene on it.
So it sounds like it's withdrawn.
Thank you. And just for the record, the email that I had received from Mr. Valkenburg, Mr. Van Valkenburg did not appear to be in an agreement to that, the finding. So that's why it's set for a hearing. So if that's what he's stating on the record, then that's fine. We'll just dismiss it. Findings were conducted.
And that's what he wants. So that's what we will do. And by the way, it is comforting to hear both parties refer to the friend of the court, Ms. Schultz, Mr. Holdwick. That goes a long way with me. I appreciate that. Thank you, everyone. That'll be all. We'll see you then. The court previously at hearing had the opportunity after hearing by stipulation of parties to meet with the minor child. In this case, the court had the opportunity to meet with the minor child. And maybe I say this too often, but I mean what I say, that give a bright young child. Really bright child. And this child, I think, is going to go a long way. So it's a great meeting, and not going to go into what we'll discuss, but suffice it to say the court had learned some valuable information that was productive as to both. That's where I'll leave it. Mr. Reed, since this is your client's,
Yes, it is, Judge.
is there anything further you wish to add?
Your Honor, as the court's aware, I just was retained on this matter the other day. And, I have it privately, but I'll say it to the court. I think it was one of the best over motions that I've ever seen filed in a matter like this. It is very professionally done. I think you get all the high notes that are necessary on a motion like this. I think his rationale for doing what he wants the court to do is there. We live in a very mobile society. Others a living example of that. She goes 6 times a day here. She's chosen to live in Clinton time. Every year and a half or so, she relocates for whatever the reasons are. My client is asking to move the child's school district, the next school district. Broad Lakes, Carson, Beaufort, Sanilac, Beaufort Line Schools, Sanilac County, which the party both agreed to. So we're not suggesting the child move out of the area or out of the state. Client has purchased a home, stable. He's maintained a home for this child throughout the course of this since the order was entered. It's a very good household, loving family, and I think that would be well. Cross like said, he's indicated he's a very nice man, very social and intelligent. I think it would be well, just as well in the prospects or in the Carson Beaufort Sanilac prospects. Certainly, kids never like to leave schools. It seems like, and that's a common problem. It's one of the kids, but parents move. various reasons. My client has laid out his reasons of motion. I think they're very rational, very good. He's not trying to interfere with mother's relationship with his child, at all. She's the one that actually has extended the mileage. If we're going to look at that, it's how far she might have to drive to Parsonsville area rather than Providence area. She lived in Huron County, I understand, at various times and chose to move to Flint. That's just the way it is. And yet she anticipates my client is going to continue ingrained in Crow's life because she wants it that way. So, Judge, I don't think that's the purpose of this. The purpose is to move rational, it's logical. I guess at the end of the day, it's in the best interest. It's not harmful to the child to move one district over, but it just isn't. There's nothing extra special about Croslex compared to Parsonsville or Sanilac. Croslex has certainly the college program down there, but we're talking about a 13-year-old child here. He's not going into that program at this point in time. Parsonsville or Sanilac is a very good school. There's a very good student-to-teacher ratio, and I think he will thrive there as well. So I asked the court to approve his request. So he's made in his motion.
Thank you, Your Honor. A few responses, and I'll try to keep it as brief as I can. First off, to suggest that this motion has no intention of interfering with my client's parenting time is patently false. There's a request here to reduce her parenting time and modify it such that Mr. has almost all the time, particularly during the week. So when we talk about whether or not this would interfere, I think that it absolutely would. My client is not asking for a modification of the parenting time schedule at this point. I don't believe that that would be appropriate. There's been no indication that she has not been able to get the child to and from school. There's been no indication that her drive has been problematic. It's been happening that way for quite some time. Even prior to her recent move, she was driving virtually the same amount of time, and that never seemed to be a problem before either. And then secondly, to suggest that it's not harmful to move this child is, again, I think false. Any child, particularly a 13-year-old that has established relationships in the school district, with friends, with teachers, etc., it certainly would be harmful to move a child, even if it is just one district over. We believe that it would not be in the child's best interest to modify the school at this time, nor to modify the parenting time. And so we are asking the court to simply deny the motion outright. Thank you.
Thank you. I will pose this question to both counsel. Obviously, you have to speak to the client regarding this.
Yeah, I don't think so, Judge. If the child would have to be transported to some location outside the school district, at the bus, and I have to cross over the line. So
I get that, but is there a bus stop? This one is my question.
Your Honor, my client has indicated that she did look into that, the closest one.
I wouldn't know the answer to that either.
The closest one to Mr. would be 8 minutes.
5 miles.
8 minutes from his home for that bus stop. My client takes the child directly to and from school, so for her it's not an issue.
I need to know that answer. I'd like to know that answer. So I don't need counsel to come back to argue unless you wish to, but I do need to know that answer. And once the court knows that answer, I can give you an opinion, or if you have the answer and you want to notice it, then you want to make a decision.
Your Honor, my client has indicated that that bus stop is located Hoverson and Lakeshore.
It's located where again?
Hoverson and Lakeshore.
I'm assuming Lakeshore is 25.
Judge, my client informs me that he believes there is a bus stop about 10 minutes away, but with his work schedule, he's not going to be able to arrange meeting the bus, waiting for the bus, both pick up and deliver. She's talking about both places to school here. So that would be getting home, 3:30 or so, and getting the bus stop, I don't know, 7:30, 8 o'clock.
Or does he also take other children to CPS as well?
there is, there are specially arranged buses for one child is, yes. County has arranged busing for that child.
So there is a bus stop.
10 minutes away, but timing is such that I don't know how to do it.
I don't need to. I don't need to wait.
I find it.
Do you have anything else?
Just in response to Mr. Potentially being unable to take the child, my client certainly has no issue taking the child every day. If she had the child primarily, point being is my client.
Well, that's not the motion.
I agree. It's simply that my client will make necessary arrangements for the child.
And just, I mean, it's not just taking the child, waiting, and then being there to pick up the child later in the day. It's going to be a part-time job for whoever's going to do it.
How's it done so far? This job was going.
The bus came to residents, but that's the problem with this one. It's bus problem came right in the front door, right?
All right, well, the motion understandably is because there was a move to the CPS school district versus the first. And there are two other children. Not of the parties here, but that fathers involved with, and it only makes common sense to file this motion requesting that the child will be moved. We already discussed the issue of mother moving to another location, an area which is still well, I would say well below, but my calculation indicates 60 miles as a protocol. So that issue has been resolved. But as to this motion, the court had the opportunity to speak to the child. And as far as I'm concerned, the child's response to the court without me divulging it makes a decision to be easier. Decision simply this: the child is to remain at house lights. The reason for it is, again, without divulging what the child may have said, information provided to the court indicates that he has strong relationships with individuals within that school district. And change, though common sense wise, it makes sense. This child has been in this district for a period of time. This child appears to work very comfortable in this school district. And to move a 13-year-old in that situation, that's the child as a result. The motion to move school districts.
If I may, Your Honor, the other two children are not just one-time involved, they are my blood children that I have.
Oh, no, and I meant that. I just said it's not a relationship.
Oh, thank you.
Thank you. On October 2nd, 2023, an order was entered regarding communication and use of app flows. The friend of the court has received information that the defendant has violated the court order regarding communication and use of app flows. This motion order to show cause for contempt was filed by Ms. Ann Schultz on May 22nd, 2024. It was ordered by the court on May 24th, 2024. And the defendant is required to appear to the court today at 9 a.m. There's a certificate of mailing as of May 28th, 2024. Ms. Geyer is present. She is the non-moving party in this matter, responded relative to the motion by the friend of the court. Mr. Pickadoo is not present. The court calls Brian Pickadoo. And I hear no response. Is there anything from the friend of the court regarding this?
Your Honor, I would just note that this complaint was filed prior to the last hearing regarding custody and parenting times. However, the friend of the court did not have a valid mailing address for Mr. Pickadoo at that time. We have subsequently been able to obtain a verified postal address. That is the address that we used for service on the show cause. And I would also note that there is still an unpaid sanction with the friend of the court office and the bench warrant for failure to appear at that hearing.
Let me explain why he's not here today. I'm sorry, Ms. McNames has Mr. McAdoo checked in. In front of the court requesting anything relative to this one.
I would request that the warrant continue with an increased bond. I believe the last warrant had a $250 bond associated with it. I would ask for a body bond. Yeah.
So amend the prior.
Yes, we would pull the existing warrant and reissue with a body bond.
Body bond will be ordered in this case, which means that there's no bond to be posted. He has to be here. If he's arrested anywhere in the state of, well, if he's arrested anywhere, essentially, there's no bond. He just comes right back to the Huron County Jail and he addresses at that time.
I would like to add to, he still to this day has not used app close. And I'm now on phone number 10 from him. I don't know what's his solid phone number. He calls me as he pleases, like to our minor child age. Normally I don't mind, but it's, if I don't do what he requests, he blows up. It's still the same behavior as it has been.
Well, there's a bench warrant now for his arrest with no bond. That's what you do.
I just wanted to put that on the record.
I appreciate it, Ms. Geyer. You're all set. Thank you.
Thank you, Your Honor.
Off the record.